at?
My name's Blake.
Do you want to go to war, Malaki? I'm for real. Ron.
Ron is here, everyone. Welcome back for more SPTV, where every day is a great day not to be in a cult. Jennifer Lopez isn't the only one going through a breakup at the moment. It was revealed yesterday in a blog post by Stefani Hutchison that it looks like Leah Remini is going through a breakup with her legal team in her lawsuit against Scientology. And the reasons given so far publicly by the lawyers is a conflict of interest has come up. And this was a statement made by attorney Brad Edwards when explaining why he and his partner were having to back out of lawsuits involving Danny Masterson's Jane Doe's and separate lawsuits involving Leah Remini. And based on the information that was provided yesterday, it seems like the conflict of interest has something to do with the revelation that Brian Kent, a board member of an organization called Child USA, the revelation that Brian Kent is being accused by another attorney of sabotaging Scientology litigation for a couple of years due to, in part, some unethical, borderline illegal sexual conduct with one of his former Scientologist clients. It seems, based on social media postings, that and a statement that was released by 3 of Danny Masterson's victims, that those victims believe that Leah Remini had knowledge of what Brian Kent had done and had not made that information public. And it appears that there's been a conflict behind the scenes between Leah Remini and the Jane Doe's, and that this is somehow the conflict that conflicted out Leah Remini's legal team from being able to continue to represent her, because they were also representing one of the Jane Doe's. And the filings that have been made public so far make it clear that the Jane Doe's, particularly Jane Doe 1, already has new legal representation set up. None of the filings make it clear that Leah Remini has any new legal representation set up, which begs the question, what happens in a case like this where someone's entire legal team has to step down due to a conflict of interest? What happens to the lawsuit if no other attorneys, or large firms in this case, because it's a big lawsuit, if no other attorneys step up to represent Leah? What happens to the lawsuit? So in order to discuss this, I am going to have a chat with my lawyer friend, your lawyer friend, Zach. All right, let me bring him on. How's it going, Zach?
Good, Aaron. And thanks for having me back on. It's been a while, but I'm glad I'm here.
It has been a while. Thank you for coming on and doing this with me. So I have always been under the impression that a lawyer wasn't allowed to step down if it left their client without representation. What say you?
So there's actually a lot of so your statement is like 85% true, but it's the 15% that we have to go to law school to understand the difference about. First off, we have to understand that any person has the right to represent themselves, themselves if they choose to. We see it most often in criminal matters, but you have the right to represent yourself in civil litigation, like this case. So there's no requirement that anybody, including Leah, have an attorney. However, once an attorney files what we call an entry of appearance, this is the public notice that, judge, I represent this client. I represent this person. The other side is not allowed to speak directly to that person. Nobody other than the attorney is allowed to speak directly to Leah Remini without going through her lawyers first. They remain the attorneys of record unless and until they file a motion to withdraw, and then the judge grants that motion. Based on the state of the litigation, I suspect the judge will probably grant the motion. If it was the eve of trial, jury selection starts Monday, probably not. With the theory being, whether you're representing yourself or you have an outside attorney, you need enough time to develop the evidence, come up with legal theories, prepare the pleadings, look at all the deposition transcripts, go through the discovery, etc. Part of what determines whether or not an attorney can keep a case or they have to attempt to withdraw from the case is multifold. One, the attorney-client relationship is a bilateral relationship. I'm a good attorney, you're a good client, we go well together. I'm a good attorney, you're a good client, but we can't get on the same page. Or your case is simply too complicated, too complex for me to get a handle on. I don't feel I can represent you adequately. Or this is so far outside my realm, I have no business even being in the courtroom on this. You're going to get run over by a train if I continue to guide the ship. That's one way. The other way is a conflict of interest, and there are rules of ethics, like all professions, that govern how attorneys have to practice. And there are from time to time, conflicts arise. There are two types of conflicts: waivable and non-waivable. A waivable conflict is where the client says, yes, I know you have a conflict, but I want you to continue representing me anyway. And that would be, for example, one attorney representing both the husband and the wife in a divorce. We've agreed on the child support. We've agreed on the property distribution. We've agreed on the support alimony. All we need to do is the lawyer to dress the paperwork up, go to court, and ask us the questions necessary for a divorce. Listen, I can't tell you what she tells me, and I can't tell her what you tell me, and I'm sort of the man stuck in the middle. But if both of you want that to happen and you both waive the conflict, I'll continue to represent you. Okay. There are also things called unwaivable conflicts, in which the depth of the conflict is so deep or so complex, or just the appearance of the conflict is so significant that nobody can waive it. And on a waivable conflict, the clients can choose to waive it, but a lot of attorneys, as a matter of principle, will say, even though this is a waivable conflict and you agree to waive, I just simply, as a matter of routine, don't represent people in a conflicted attorney-client relationship. I just won't do it. Malpractice reasons, whatever. And so for any number of reasons, an attorney can terminate the relationship. If paperwork has been filed and litigation started at the courthouse, the attorney has to get permission from the judge. They file a motion to withdraw, and the judge, and sometimes, so it's real simple. I file the motion, and then I state, what is the status of the case? We haven't issued discovery. Discovery's outstanding. There's no trial date, whatever. That I've informed my client of my intent to withdraw. The client supports my motion to withdraw. Or maybe the client doesn't want me to withdraw, but I'm trying to fire the client. Okay, I just have to give the court notice of the status of the case. Generally, the other side, in this case, the defense, they can't really object because they don't get to dictate who represents the plaintiff, right? Each party has the right to choose their own attorney. And then the court will say yes or no, grant or deny the motion. I suspect the motion will be granted here. If the motion is granted and Leah does not have backup counsel or replacement counsel or whatever, the judge, assuming grants the motion, the judge says motion granted. Plaintiff Leah Remini has X number of days, 30, 45, 60, 90, whatever the rules and the judge's preference call for, to either retain new counsel, hire a new attorney, and have that attorney enter their appearance, or file paperwork with the court that says, I, Leah Remini, am going to represent myself. And if you don't do one of those two things, either hire a new attorney or file your intent to represent yourself, by the deadline, as the plaintiff, the judge will very likely dismiss the case.
Oh, the judge can do that. That was my question. That was actually, I didn't realize that was one of my major questions, but it was. So let me ask you this, as far as the subject of a conflict of interest, because you were giving examples of conflicts where it would be up to the client to potentially waive that conflict. It seems that in this case, it's a conflict that came up that the lawyers themselves said we can't keep representing either of these clients. And it wasn't even something that was up to the clients. It was a decision made by the lawyers.
Yeah, and that's very common. We see this from time to time. For example, a lot of judges become judges after they leave private practice. And at some point, one of their former partners, business partners or law partners, may end up in front of that judge. Or there may be maybe I leave firm A and I go to work for firm B. Firm B has a case that I was on the other side of when I was at firm A. And even though I'm not going to be working on it, firm B is now conflicted by virtue of having me in the building.
Got it.
And those are sort of interior conflicts, but there's also exterior conflicts. For example, there may be, if I may have a relationship with somebody who's facing bar discipline, as in the case of the Child USA situation, right? All kinds of inappropriate conduct. And for example, let's say the attorney who's in trouble, the Child USA, Brian, what's his name?
Brian Kent, yeah.
Yeah, Brian Kent. Let's say at some point, Brian Kent was represented by Leah's attorneys in trying to resolve these actions he should not have taken, whether civilly, criminally, legal malpractice. A lot of legal malpractice claims are settled without going into court, but it's very possible they may have represented him, maybe his malpractice insurance. There may be such a close connection to him and this Jane Doe that they just can't separate themselves enough, and they are no longer legally qualified under the rules of ethics to provide representation to Leah.
Okay, so theoretically then, if a legal team was representing Leah Remini on one case and Jane Doe's in another case, but it was the same legal team, same clients, different cases, and if one party said, I'm going to sue, if one client said or threatened to sue one of the other clients for stuff they were saying publicly, would that create an automatic conflict?
Yeah, that would create an automatic conflict. And I would argue, and the rules probably very clear on this, I just haven't looked at the rules of ethics recently, as far as like the nuances. Some of this stuff you have to go back and look up. To me, that is very much an unwaivable conflict because I'm representing parties A and B, but then B sues A. And at some point, I'm going to end up adverse to somebody in that case. I'm either going to end up adverse to A, or if I continue to represent A against in the action against B, I can't also represent B because now I'm on opposite sides of two different cases involving the same set of clients. That's
right. It did also occur to me as well that one of the problems with clients being represented by the same firm, and then these clients or one client threatens to sue another client. One of the problems is they're basically, one of these clients is calling the other client a liar. And so it seems to me that in the Scientology litigation, Scientology would just be like, oh, your two clients are publicly saying, or one is saying the other's being dishonest. They could use that to their advantage. Like Scientology could subpoena those people. Do you see where I'm going with this?
Yeah, absolutely. And essentially, party A and party B, not only are they going to be adverse, they're going to be subject to discovery against one another. Because if B sues A and I represent A and B, at some point I could get a subpoena and have to testify and provide testimony about things that are not subject to the attorney-client privilege. Well, now I'm conflicted. I have to get out of the case. And if it is an unwaivable conflict, even if trial starts tomorrow morning, if it's an unwaivable conflict, generally speaking, judges do have to grant that motion because I don't have the legal authority to represent these parties or one of these parties. This conflict is not waivable, so I legally don't have the authority under the rules to be here today.
That makes sense. The scenario that we just described, would all of that still hold true if it was just a threat to sue, even a threat made in a fit of anger? Would that be enough for a law firm to go, all right, we're leaving now?
Probably. They would not be required to. The conflict doesn't exist until either a suit is filed or the demand letter, right? Pay me money or I'm going to sue you. Until it escalates to that level of a lawsuit or a demand, the conflict doesn't exist. But just the appearance of that conflict, like, hey, the building's on fire. The room I'm in is not burning, but the building's on fire. I'm going to go ahead and run before my door catches on fire and I'm stuck trying to jump out the window.
Got it. What about a scenario where you have a team representing two separate clients in two separate cases, but one client demands that the firm fire the other client or else?
That becomes an unwaivable conflict. So the firm has a choice to make. Either they fire client B, but then they burn that bridge with client B. Because again, I can terminate a client for any reason. We don't get along. I'm too busy. Not my kind of case. Whatever. Maybe I've shifted my practice to something that doesn't involve this, and I don't want this sitting on my ledger anymore. Whatever. I can fire a client for any reason, just like a client can fire me for any reason. So if the ultimatum is made, I can fire the client and stick with client A. But if client A is demanding I fire client B, at some point they're going to demand that they fire me too. So I'm just going, again, sinking ship analogy. Okay, they've kicked this guy off the ship. I'm going to go ahead and get off before it hits the bottom of the ocean because the North Atlantic is cold in January.
Right. Okay, and I made a statement in the video that I did about this yesterday and just want to verify its truth with you. One firm representing two clients. One client demands that the other client be fired or else. Is the law firm even allowed to pick and choose which client they're going to let go? Or are they sort of automatically required to get rid of both clients?
So the discretion exists in the firm. They can fire client A, they can fire client B, but in reality, they probably will fire both clients. I say fire loosely, just basically end the attorney-client relationship. I no longer represent you. I'm not going to go to court, not going to do any legal work for you on this matter. They will probably dissolve both attorney-client relationships and walk away. Just because you don't want to be stuck in the middle of he said, she said, and then everybody goes to Google and starts putting out bad Yelp reviews and filing bar complaints. It's easier just to get out of the mess completely.
Right. So it's almost like one person who thought that they could throw their weight around in a particular way and demand that a firm fire another client or clients might have inadvertently been responsible for their own firm dropping them because they didn't quite understand how all this works.
Well, exactly. And that's, the rules basically say if you want to fire an attorney, or if you think, somebody has violated a rule, a rule of ethics, or you want to fire your attorney, you have the right to actually go consult a different attorney and get legal advice on, can I fire this attorney, whatever. But essentially, yeah, sometimes you step over nickels or you step over dollars to argue over nickels. Right. And, cool. I demand that you fire the other client. Cool. I'm going to fire you also. I'm not going to work with either of you people anymore. And if I've done my job and built my reputation in my firm, I got 10 people standing outside my door that are going to generate money for the firm also.
Right. Okay. Now in a situation like this, where it seems messy, in order for the lawsuit to go on, it seems that another firm is going to have to view this entire landscape and say, yeah, we're comfortable waiting in and picking this up. Can you help me understand how this works? Given confidentiality and attorney-client privilege concerns,
Sure.
How is a new firm even able to do their due diligence to find out what went wrong in the first place in order to make a decision as to whether they want to step in?
So it's a multi-step answer. The first answer is we have to remember, who does the attorney-client privilege protect? It only protects the client, not the attorney. So I'm never allowed to tell what my clients told me, but if my clients want to go to the coffee shop and tell all their buddies what they told me, that's their right. If they fire me and they solicit a new firm to represent them, if that firm reaches out to me and says, hey, I've been retained by client so-and-so, can you please transfer all relevant file materials to me? Any discovery that I've issued or has been responded to, that's not protected by the attorney-client privilege. Any pleadings I've filed, any internal memos, emails to the client, I'm not going to turn any of that over. But I am going to turn over, say, medical records, depositions, any evidence that I've gathered, witness lists, anything that I have done that would be otherwise discoverable. For example, when we get ready for trial and I have the pretrial conference, I got a list. Here's all the witnesses that I want to call. That's not a secret. We don't do trials by surprise anymore in this country. So anything that's not protected by the attorney-client privilege, which is generally conversations between myself and the attorney, or what we refer to as the attorney work product doctrine. I sit down with my client and we're having a discussion and I take notes. I'm never turning those notes over, ever.
Right.
But the pleading that I filed or the letter that I wrote to another person in response to that meeting, I will absolutely turn over, but not the notes themselves.
Right. So I try to put myself in the position of a potential new firm, and I try to imagine what questions or concerns I would have. And I feel like I would go to the client. In this case, let's just say the client is Leah Remini. I would go to the client and I would say, well, you have a firm who's already spent millions of dollars and, I don't know, a year or two of work on your case, and they're walking away. We need to know why, so that we know what we're getting into here. And I feel like no matter what information the new potential client provided, as a firm, I would still be wondering, am I getting the truth? And I feel like I would ask the client to ask her to authorize the previous firm to release all information to me about the source of the conflict. Is that something, like, if the new client says, yes, that's okay with me, they can release all the information?
If a client signs a waiver and a consent for me to request from the old lawyer or the old firm all documents related to the conflict, then I can absolutely, because again, it doesn't protect me, it protects the client. If the client waives the privilege, they've given me consent to tell that information to whoever they tell me to disclose it to. I still can't go to the coffee shop and tell my buddies, but I can tell firm B if firm B sends me a written release. And a classic example of this that a lot of folks should understand is medical records. You go see a doctor and they say, fill out this form for who you want us to release your medical records to. and I say, I want you to release it to my wife and to my primary care doctor. They're not going to unilaterally call my wife and say, hey, we're faxing you these medical records. But if my wife calls up or my primary care doctor calls up and says, hey, could you send, email, fax me the medical records from this visit, then they will absolutely do that as long as their name is on the list. They don't unilaterally do it, but if requested, that form gives them consent to release those documents. It's the same theory.
I get it. I get it. Now, Motley Rice and Bradley Edwards are the firms, Motley Rice and Bradley Edwards' firm are the firms that have been representing Leah up until this point. I'm going to guess that they've already incurred millions of dollars of costs, at least $1 million. I'm going to guess it's multi-millions of dollars of costs. And that I'm going to guess, please jump in, let me know what you think, that even though they're stepping down, they are still entitled to recover their costs if Leah's lawsuit moves forward and results in a settlement or a victory, right?
Possibly and probably, because so the way that works is essentially if they have put work in the case or they're anticipating putting work in the case, they will file an attorney's lien. Just like a home builder would file a mechanic's lien before they actually turn dirt to make sure that they get paid by the homeowner. I can file an attorney's lien. And then as long as I document my records, we paid $200,000 in, such and such fees. And then our billed time adds up to $1.2 million. That was unrealized, uncollected because it was on a contingency. As long as I have the records to support it, I'm basically a secured creditor. The collateral is the recovery. Now, where it gets tricky is, for example, she's seeking a court order that says they're no longer allowed to engage in fair game. There's no monetary value associated to that injunction.
Right.
So that time was probably billed on an hourly basis. So we call it time and expense incurred basis. But as far as I'm suing you for $1 gazillion for all this pain and suffering and loss of income and tortious interference with business and all these other claims that survived the anti-SLAPP challenge, most of them did, then there's a cash value to that. And I'm entitled to recover a percentage of that based on how much work I did. Let's say at the end of the day, the current firm did 1/3 of the work and the future firm does 2/3 of the work and the recovery is $10 million. My firm gets 30% of the attorney's fees that are recovered. So let's say on $1 million, the attorneys get $400,000. I would get 1/3 of that $400,000. So I would get a prorated percentage of the attorney's fee and recovery.
The fact that you could have a firm, and by the way, the blog post yesterday didn't specifically reveal that Motley Rice was conflicted out as well. But based on the information that was revealed, it stands to reason, and I'm going to guess that Motley Rice is conflicted out as well. Given the possibility that there's a multi-million-dollar lien going to be coming against the settlement of this case, does that have any impact on the likelihood of a new firm wanting to step in and pick up where Motley Rice and Bradley Edwards and his partner left off?
Certainly. As to how significant an impact it has is a moving target. If I'm a two-man show, 2 attorneys and a part-time paralegal, that's a huge risk. If I got 900 attorneys and $7 billion a year in revenue, it's a Tuesday for me. Right. So it sort of depends on, anytime an attorney takes a case on a contingency, they're taking some of the risk with the client. That's the ad. You've been hit by a truck, call us. No recovery. You don't owe me anything, right? No recovery, no fee, that thing. So the attorneys are going to do an analysis like, can we afford this? And I don't just mean, do we have the cash in the bank to front all these expenses, but also, do we have enough labor to put in the time, the writing, the researching, the depositions, the meetings, the enormous human cost to something like this? Is our firm in a position to prepay that, or is this a bet the farm case? And some firms are in the business of taking bet the farm cases, and they're gambling, and they're analyzing that case based on the fact that if I lose, I have to close my practice and I'm going to go work in the public defender's office. But if I win, I'm going to buy an island and you're never going to see my pale face again.
You mentioned taking it on contingency. I feel like this is going to be a major issue in whether a firm's willing to step in here, because if a firm's actually just being paid upfront by the client or with a huge retainer for their work, then what do they care? What do they care about all this other stuff? Correct. But my recollection is that my recollection is that in the hunt for firms leading up to the filing of this lawsuit, the only firms that were even being considered were firms that were willing to work on contingency, because the money simply doesn't exist to pay these lawyers up front.
Correct.
And I guess I'm asking your opinion on when a firm agrees to take on a case on contingency, they're making a big gamble. And
Exactly
when I said earlier that I try to put myself in the shoes of a potential new firm, I'm going, wait a second. So a very respected and powerful firm already took a huge gamble on this case, has already put in over a year and millions of dollars of work, and they're stepping down. That seems to raise the risk profile of the case in general.
I agree. If you think of the firm Morgan & Morgan, of which I'm not affiliated, but it is probably the largest national personal injury firm in America. If I'm a medium-sized law firm and somebody comes to me and says, hey, I want you to take my case, I used to be represented by Morgan & Morgan, I'm going to ask myself, what in the world happened with your case that Morgan & Morgan won't touch it? Morgan & Morgan will touch everything. And there's nothing wrong with that. They have the resources to take low value cases and the ability to afford the risk of high value cases. There's nothing wrong with that. But if Morgan & Morgan ain't going to touch it, what in the world am I going to do to possibly help you? That's my analysis. I'm a good lawyer. Morgan & Morgan has great lawyers. If you come to me with a really complicated case, I'm going to find you a Morgan & Morgan type firm that specializes in train wrecks and rabid dogs, because I don't do either one of those. Right. So if somebody comes and says, hey, Morgan & Morgan had it, but they don't have it anymore, my question is why? Okay. And that goes back to what you asked earlier, which is I'm going to get a signed consent from the client that says, hey, before I sign you up, I want you to sign this consent so I can get documents from Morgan & Morgan, not just about the case, but also why didn't they have it?
Right. So what's interesting is that
why are they getting rid of it?
Yeah. What's interesting is that finding out yesterday from Stefani Hutchison's blog post that it looks like Leah Remini's entire legal team is conflicted out explains something that happened in her case that I didn't understand, and so I didn't do a video about, which is that David Miscavige asked for a stay and Leah Remini's team agreed. Now it makes sense why they agreed. The stay that was agreed to, and I'm going to have to double check this to make sure my memory on this is correct. The stay that was agreed to was such that it looked like that lawsuit might be on pause for as much as a year. That makes sense if you consider that she already knew her legal team was going to conflict out and didn't know what to do next. And so agreed to a stay on the lawsuit so that David Miscavige could go do, another little thing and make another little motion. But Leah Remini's team had the option to not agree to the stay. And they did agree to the stay. And the Jane Does had a similar thing happen in their case, and they did not agree to the stay. And now it makes sense if we consider the possibility that Jane Doe 1's legal team was conflicted out, but she already has new representation. Leah Remini's legal team is conflicted out, and she doesn't. And so it's possible that even with this conflict, it's possible that we don't hear anything about it and nothing happens for like 6, 8, 10, 12 months. That's totally possible, right? Even if they have a conflict, if they're not required to do anything right now because the suit is on a stay, it might just be business as usual until, well, I guess this actually brings me to my next question. If the firm has to conflict out, but the case is currently on a stay, can they just coast and not do any? At what point would Motley Rice have to say, we need to withdraw?
Well, essentially, as soon as they know of the conflict, they must, within a reasonable period of time, so as soon as is reasonably practical, resolve the conflict, either ask to get out of the case or get the required waivers to waive the conflict, which is not going to happen. This is not necessarily a waivable conflict. And so as soon as they're aware of the conflict, then they have a duty to notify the client, notify the court, and immediately seek a remedy to the conflict. So they can't go, well, we know of a conflict, but the case has stayed. We're going to be sitting here for 10 months. Let's just back burner this and come back to it over Christmas. They either have to piss or get off the pot. You either handle the case or you either get the waiver or you have to get out of the case, because if the case has stayed, that is an excellent time for an attorney or attorneys to be reviewing this case to determine, do I want it? Most of the time, we've got like 72 or 96 hours sometimes to decide if we want to take a case. They've got months to do independent investigations and to talk to witnesses and to review pleadings and to check the law and to do all those kind of things that not everybody has time to do. So this is the time to get rid of the case. And they do have an ethical obligation, the attorneys do, to, once a conflict is known, notify the client, notify the court, and by notifying the court, they notify the other side, the other parties, and then resolve that conflict either with waivers or get out of the case.
Got it. Got it. I guess there's always a possibility that Motley Rice, I can think of reasons why this would never occur, but I'm just, trying to be as charitable here as possible. I guess there's a possibility that once the conflict, depending on how it's being viewed as a conflict, is resolved by Jane Doe 1 now having different representation, theoretically, Motley Rice could go, all right, we no longer have a conflict. We're okay. We'll just
Absolutely.
Unless it was one of these things where, well, I guess it is possible, isn't it?
Yeah, that's absolutely true. Yeah, like in this case, one of the ways you can get rid of the conflict is you can get rid of one of the clients and keep the other client. But in theory, the conflict could still exist on paper because maybe the client you got rid of told you something helpful or hurtful to client A's case, but you can't use any of that information, especially if it's helpful. That, hey, client B told me something that's super helpful to your case. If you can't figure out how to independently go get that information, you're not allowed to use it because it was given to you in confidence as part of the attorney-client relationship.
That's right. That is right. And actually, based on the information that was revealed yesterday, it does seem that the conflict has to do with the attorneys who were representing both Leah and the Jane Does, the attorneys being informed that Leah Remini knew about Brian Kent's behavior for a long time, and that Leah Remini is associated with Child USA, and that Leah Remini either never told Child USA or that Leah Remini did tell Child USA and Child USA is lying. Because Child USA says their board had no prior knowledge of this, except Mike Rinder is on their board. So if Leah Remini's attorneys have been informed that Leah Remini did have advanced knowledge of this, then we are to believe that either she never told Mike Rinder, or Mike Rinder never told Child USA, or Child USA is lying. And all of this seems very messy, in addition to the fact that one of the attorneys representing both Leah and the Jane Does is on the board of Child USA. It's pretty obvious that Child USA is the source of the conflict.
Yeah, absolutely. And so now,
I guess
as to which particular type of conflict and how the conflict is created, I don't completely understand. But you're right. The nexus, the pivot point about all of these issues is Child USA. So whether it's Brian Kent, whether it's Leah's knowledge or lack of knowledge, whatever it is, there's something about Child USA that's causing the conflict. You're correct.
Right. Well, the thing is, Brad Edwards and Brittany Henderson were, two of the attorneys representing both Leah and Jane Doe 1. Brittany Henderson's on the board of Child USA. Leah Remini is an ambassador for Child USA. If the attorneys are informed that that without any question at all, Leah Remini had much prior knowledge of Brian Kent's activities, and yet you have Child USA saying the board had no prior knowledge, I can very easily see how this is a huge conflict, even if only due to the fact that these parties could be subpoenaed to basically sort of testify against each other.
Yeah, and so it sounds to me, based on what you've said and the little bit of reading that I've done on this, because I saw your video on this yesterday, by the way, is that the conflict exists instantly because of Child USA, and there's really no way out there's no way for the attorneys to deconflict, right? So it becomes unwaivable. And if it becomes an unwaivable conflict, the attorneys by rule can't stay in the case. The ability to represent a client or to handle a case is based on your ability to satisfy the ethical requirements. And in this case, they can't satisfy them. So they are not qualified, not in a normal sense, but in a very unique legal sense, ethically, they do not qualify to represent either the Jane Doe or Leah here because of this connection running through Child USA.
Right. There's also, and I'm just going to say this publicly because the evidence of this already has been shown publicly. You had Stefani Hutchison doing blog posts attacking the Jane Does and attacking me. And then you had public evidence on social media that Leah Remini was encouraging it and cheerleading for it. Now, it doesn't matter if she's cheerleading people attacking me, but if she's cheerleading attacks against the Jane Does who are being represented by the same attorneys who represent her, then we have multiple conflicts of interest here.
Correct. And you just need one. The fact that this is 4 layers deep is what is unique. That sort of is unique anyway. But when you add additional layers to it, it makes it very clear that the attorneys either can't or have decided we're not going to untie this knot. We're just going to leave this on the table. We're going to walk away and we're going to wish the best of luck to whoever wants to come in and pick this up behind us. And that's not to say there's not another firm that's very qualified to handle this. There's a gazillion lawyers out there. You know, what is it? One of the guys I work with said, what do you call 2 lawyers who drive off a cliff in a Cadillac? Well, you have mixed emotions about it. You know, so it's sort of the same, at least in concept, right? In that there's very qualified lawyers who would pick this case up and can very likely be very successful with this case. But there's probably less than 100 lawyers in the country who have the competence, the experience, and the financial backing to take the risk.
Yeah. What I find interesting, and I'm not entirely sure what to think about it, is that the other cases, the other Jane Does, the 2 other suits, Boyce Schiller is perfectly willing to take those suits on, those clients on, and run forward with them straight to the end zone. It's interesting to me that out of these 3 lawsuits, the one that's become the most conflicted and the most toxic is Leah's, and the other 2 seem to be moving forward just fine. And I'm trying to, and that is what leads me to believe the conflict was created by Leah, not the other clients. That's my takeaway from that. But, you know, I imagine there could be more than one takeaway.
Yeah. And, you know, for anybody who's out, whether they're on YouTube, whether they're making blog posts, and they're sticking their nose into this case, they have to be very careful, because you run your mouth too much, eventually you have to answer to that. And at some point, you're, especially assuming really, you know, a good lawyers get involved, there will absolutely be subpoenaed. Oh, okay. You're making these claims. I need proof of these claims. Oh, you take issue with this. Well, I didn't say that. Well, here, let me read you your blog post. Well, did you make that up? Because you pawned that off as a statement of fact, which could be defamation. I want to see all the proof you have to support these allegations. Because remember, the freedom of speech, the First Amendment, does not protect you from civil litigation. It only protects you from government censorship of what you're saying. Everybody is responsible for everything they say every day, including YouTube videos and blog posts and whatever else. And so, you know, there are people in this world that are trying to stick their nose into this case. Not you necessarily, but other people are trying to stick their nose in this case, and they very likely may find themselves crosswise with really good attorneys who are saying put up or shut up, and if you don't, we will either get a gag order or we will sue you for an injunction for a court order to shut you up.
Right. Well, I mean, it's interesting that you say that. And you're probably referring to what Stefani said in her blog post, which was Stefani said in her blog post specifically that the reason for the conflict was Jane Doe 1 leaking privileged information to me, and that created a conflict. Not only is that completely false, it's not even sensical, because, like you said, the privilege is the client's.
Yeah.
You can't conflict out an attorney by talking to someone about your case.
If Jane Doe wants to come have a cup of coffee and put the entire case file on your desk for you to peruse and do videos about, that's her right. Now, if you're disseminating all that information to the public, if I'm her attorney, I'm saying, hey, shut your mouth. This is making it really hard. But that's not what happened here. But even if she did, it's her right to do that.
Right. Well, and here's where I start to get very, very troubled. And well, I mean, obviously there's many places where I've started to get very troubled, is that Stefani Hutchison could not possibly have come to that conclusion or have had any reason to believe something like that could reasonably true unless she was given the information from someone who she believed would have known, which in my opinion is no one other than Leah Remini. So that's where I go. You have Stefani Hutchison putting clearly and obviously false information out there. And then you have the appearance that she's being leaked that information by Leah. And you go, the conflicts here keep stacking up.
Yeah.
And so, you know, but again, you can't prove, you know, the who's trying to feed false information to Stefani, but you do have Stefani who's publishing provably false information about the Jane Does.
And here's the thing. As long as you're not taking the deposition of the person for whom the privilege protects, in this case, Jane Doe, I could issue, if I'm an attorney in the case, I issue a subpoena to Stefani Hutchison, and I say, you're going to tell me right here under oath where you got this information, or I'm going to go to the judge and ask for a citation of contempt, because a subpoena is a court order to appear and answer questions. If you don't answer my questions, or if you lie to me, I'm going to have the judge put you in jail until you're willing to tell the truth. Anytime somebody goes lie with a statement that they're not willing to put up or shut up, they've exposed themselves to civil liability, and they can't yell First Amendment, First Amendment. First Amendment protects you from the police beating you with a baton because you had a pro or anti whatever sign. It does not protect Karen from the Starbucks Christmas cup. It only protects people from government censorship. You are still responsible in a civil perspective. You are still responsible for what you say, what you publish, what you write.
Yeah.
And
what if Stefani claims that she has journalistic protection and doesn't have to reveal her anonymous sources?
Well, if she's going to claim the journalistic protection, she's going to have to prove she's a journalist and not just a keyboard warrior. Those are two very different things. And there are legal tests to determine whether or not someone is a journalist. Even if they're a freelance journalist running their own blog, they may still be a journalist. But me going on YouTube and opining to legal cases makes me no more journalist than standing in the garage makes me a car.
I'm going to have to use that one. I've been using a phrase recently was, and if my grandmother had wheels instead of legs, she'd be a bicycle. Okay, this has been awesome. Let's jump through. The lovely Barbara, SPTV Tattoo Warrior, has been starring some comments in the back office. Hey, Barb. Let's bring up some comments here. Oh no, Nora's in the chat. Good to see you, Nora, here bringing her popcorn. Abigail says, question, can you comment on the anti-slap win? Not only am I going to comment on the anti-slap win, Streets LA and I are going to do a live stream about it in about 30 minutes. I don't know if you know, Zach, but there was an anti-slap hearing in the restraining orders that La Poubelle was taking out against Streets and DOA, and the hearing was this morning, and it was a complete victory for the protesters. So,
oh, perfect. That's awesome.
Stay tuned for that. Arnie Van Halen says, I'm sorry, but I really love the videos where you show the receipts and pull their pants down. Legend. Thank you. Thank you very much. Failed pessimist. I need a coffee mug with "It's Aaron's fault." Yes. Hashtag "It's Aaron's fault" has been making a strong appearance the last 24 hours. Let's see here. Roberta. Aaron, do you know what I like about you the best? It's the fact that I can believe anything you say because you fact check before you open your mouth. Well, I do appreciate the compliment, but definitely don't believe everything I say just because I say it, just because that's a dangerous way to operate. But I take the compliment. I take the compliment. Oh, definite trouble source. So I'm more confused now than ever before. Is Aaron to blame for J-Lo's problems or not?
Well, it depends on who you ask. According to Stefani, it's Aaron's fault. It's hot in Oklahoma in this summer.
Oh my goodness. NatCat 180. Zach, do you think Leah will have trouble finding new counsel?
I don't know that she's going to have trouble finding at least counsel who are interested. But as I mentioned earlier, there's probably less than 200 lawyers who are affiliated with law firms that have the competence, the experience, and the financial backing to carry this case all the way through. So I don't know that she's going to have trouble, but I think it's going to be a tenuous process for both Leah and for potential future attorneys. Lots of research. And essentially, when these firms are screening these cases, they're eating that research cost. They're eating that due diligence cost. And if let's say you got 10 lawyers that you're billing at $700 an hour, that's $7,000 an hour to research this case. I mean, there's an impact. There's a financial impact to the firm to investigate these cases. So indirectly, I don't think it's going to be she's going to have trouble finding interested counsel, but I think it may be difficult to retain the right counsel.
Right. That makes sense. Constance June. Does Brittany Henderson being on the board of Child USA impact this? In my opinion, without question. You had this crazy incestuous conflict here where you had Brian Kent, board member of Child USA, who'd been representing a whole mess of former Scientologists. You have Mike Rinder, who's on the board of Child USA. You had Leah Remini, who's the ambassador of Child USA. And then when Brian Kent's, Brian Kent's victim was someone who was a friend of Mike's and Leah's. So, and then when this all comes out publicly, Child USA's board says, we had no knowledge of any of this. And we go, well, we know for a fact, it is an indisputable fact that Leah Remini had prior knowledge of this. And we go, so what do we believe most? That Leah never told Mike Rinder about this? Do we really believe that? Do we believe that if Mike Rinder knew, he didn't tell Marcy Hamilton? Do we really believe that? Do we believe that if Marcy Hamilton knew, she didn't tell the board? Do we really believe that? Some of these things could be true, but we get to less and less believability. The least believable part of all of this is that Leah Remini would have never told Mike Rinder about this. That's the least believable part. So then you have the fact that Brittany Henderson, as a board member, then becomes aware of these things, and she's being aware. She's learning that her client Leah Remini is being accused of having prior knowledge. Anyway, I feel like Brittany's involvement in Child USA has a huge impact on all of this personally. But then you also have the fact of just a client threatening to potentially threatening to sue another client, and it's almost like even if Brittany wasn't associated with Child USA, you would still probably have a conflict arising here.
Yeah, absolutely.
Okay, so Quetzalcoatl. Oh yeah, this is a question I actually did mean to ask you about. Does the attorney have to reveal the conflict to Leah when they drop her? Well, of course they do, but let me ask you a different question. I imagine everyone involved would rather there was absolutely no documents filed in either of these cases that give the details of the conflict. How does that work out?
So the conflict itself, the fact that a conflict exists becomes public record when the motion to withdraw is filed. The basis for the conflict, like for example, say an unwaivable conflict has arisen, and therefore we respectfully, move this honorable court that the firm be withdrawn of counsel, and that the plaintiff be given a date certain to proceed. Right, whatever. Now the judge has the right to say, okay, what is the basis for this? But that's often done at oral argument. And if it's involving things that are sensitive in nature, for example, communications internal to Child USA or something, or allegations against somebody, whatever, those matters can be taken up what we call in camera or in the judge's chambers off the record. And then the judge would come back and on the record say, I've met with the attorneys. The conflict has been explained to me, and I agree that there is a conflict. That's an unwaivable conflict, and I'm going to grant counsel's motion to withdraw. Counsel is hereby withdrawn. Whether they do that in open court or they do it through a filed order is sort of at the discretion of the judge.
So if Motley Rice were to go to Leah and say, we need to part ways due to this conflict, our own attorneys have advised us, we have no choice. And if Leah says, no, I'm not going to agree to that, does that then force a situation where Motley Rice would then have to go into court and actually provide all the evidence in open court to the judge as to why? Like, I'm guessing that it's one of these things where it's like, hey, we need to part ways. We can do it nicely and in private, or we can do it contentiously and in public. Is it one of those things?
Yeah, it could be. And if for some reason there was a pleading file that had some of this information on it, they could ask the court to seal it. Right. Like it's part of the record. So if it ever goes up on appeal or a future judge, let's say the judge gets reassigned to a different judge or something. The other judge can go and look at that and see that sealed record that's not available to the public, but may matter to the judge in making decisions.
Right. Guys, if you're watching us live right now, please do me a quick favor and hit that like button if you don't mind. And actually, just before I forget, we have more questions to go through here, but I just want to show you guys, if you're not yet subscribed to Zach's channel, you can find him at Your Lawyer Friend Zach. All right, let's see here. What do we have? That's not the one. Yeah, I love Zach's analogies. Yeah. Just because I'm in a garage doesn't make me a car. Okay, what is this? Steve Jackson. Is it possible that some attorneys may offer to take on the case due to the publicity and opportunity to get their name out there, particularly in Los Angeles?
Oh, of course. I mean, that's always true. I guarantee you that Johnny Depp's law firm lost money on that case.
Oh,
Because ultimately it was settled for like $1 million or $2 million. Amber Heard ended up paying Johnny Depp like $1 million or $2 million. They lost money on that case. But within days of that case being over, Camille Vasquez was on all the talking head shows. Fox, CNN, Good Morning America, The Today Show. Ben Chu has now been a contributing correspondent to all the talking head 24-hour news networks also. And that will pan out for them, and they'll make 100 times what the firm could have made just in public appearances, because people don't appear in public for free.
right.
So absolutely, that's absolutely something somebody could do. And even if they're willing just to take the case for publicity and not make any money on it, they still have to have the cash reserves to pay the jury fee and to pay the consultants and to pay the experts. And they have to be willing, and they have to be in a financial position to say, I've invested $5 million into this case, and if I never get a nickel back, I'm okay. They have to be in a financial position to take the risk of loss also.
Right. That makes sense. All right, guys. Well, I think that's it for us on this subject for now. Stay tuned. Very shortly here, I'm going to go live with Streets LA talking about his anti-slap victory over La Poubelle and Francois Coster. Thanks for doing this with me, Zach. I really appreciate it.
And guys, if you hop over to my channel after Aaron, sometime tonight, probably, if not tomorrow, Oklahoma Supreme Court handed down a huge case revolving religion in schools. So if that's something you guys are interested in, I'm doing a video on that later.
Nice. Thanks, guys. We'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,